Today's courtroom hearing starts off like a routine bail review, but it quickly becomes something much more intense. A woman facing multiple charges, including violating a protection order, stands before the judge without a lawyer, choosing to represent herself in a situation where every word matters. She's already missed hearings, she's already been taken back into custody, and now she's asking the court for one more chance. At first glance, this may sound like a simple request for release, but the stakes here are enormous. The judge isn't just deciding whether she walks out today. He's deciding whether she can be trusted at all, and that trust has already been damaged. The prosecution points to missed court dates, repeated legal trouble, and concerns about the alleged victim's safety. Meanwhile, the defendant pleads for mercy, insisting that she's learned her lesson, that she has nowhere to turn, and that jail has pushed her to the edge. What makes this hearing so gripping is the balancing act unfolding in real time. Justice versus compassion, risk versus rehabilitation, law versus human desperation. Will the judge see a woman trying to fix her mistakes, or someone who has already proven she can't follow the rules? Because in hearings like this, emotions may fill the room, but credibility is everything. And when the judge begins digging into her history, the direction of this case can change in seconds. Let's see whether this defendant earns freedom or hears the courtroom door slam shut.
Case. And today was just to address bail, is that right?
Yes, sir. Yes, sir.
All right. Okay. Well, so a change in release conditions does require new information, a change of circumstances, or sort of similar good cause. A judge has previously imposed those bail amounts. I'll let the prosecutor also weigh in, but I'll start with you, ma'am. What information can you give me about why a reduction in bail or personal recognizance release is appropriate here?
Can I have a breakout room with the prosecutor, please?
Well, I suppose if you're not represented by counsel, is that something that's up to you?
I'm not the attorney assigned to this case. I'm willing to speak with the defendant, but I don't know how much good could come of it. I'll just be quite honest.
Okay. Yeah, I mean, ma'am, one of the benefits of having an attorney is they're able to have those conversations. Mr. Libby here is assigned the jail calendar today, but he's not the prosecutor on your case. So it's unlikely that he'll be able to make any substantive decisions other than asking that, dates remain set.
It's okay.
Are you still wanting to speak with him?
Yes, sir.
It's up to you.
I mean, yeah.
Okay. Yeah, so we can set up a breakout room. I'll take the private case while that's.
Your Honor, actually, I've spoken with Ms. Pritikin just now, who's the assigned DPA for, I believe, the 2 DV cases of the defendants. She's willing to speak with her right now. I think that might be a more productive use of time, actually.
Okay. All right. I think in order for that to happen, you said that was Ms. Pritikin?
Nicole Pritikin, yes, Your Honor.
I think she would have to sign into Zoom and then get a breakout room with the county jail. All right, so Ms. Martini, the assigned prosecutor on your case, someone named Nicole Pritikin, she is going to be signing into the Zoom hearing here, and then we'll put you in a breakout room together.
Okay.
This is where the hearing takes a serious turn. The prosecutor isn't willing to support any change in bail conditions, and that matters more than many people realize. In bail hearings, the prosecution's stance can heavily influence whether a defendant gets released, especially when there are concerns about public safety and court compliance. And right now, the biggest issue isn't even the original charges. It's the fact that she has already failed to appear in court before. To a judge, missing court dates sends a dangerous message. If released, this person may not come back. That's the heart of the problem. The defendant is trying to explain the missed appearances, blaming unstable circumstances, lack of communication, and personal hardship. But the prosecution is focused on a different question. Can the court rely on her now? That's the battle in this moment. Excuses versus accountability. And you can already hear the judge weighing both sides carefully. He isn't rushing. He's looking for something that justifies taking the risk of release. The big question is, has she done enough to earn that trust back? Because if the answer is no, she stays behind bars.
Custody for the probable cause hearing, and then you were released. You failed to appear for the arraignment. You were back in custody on another charge. So it seems like the only time
I did appear for the arraignment on the streets when for one of the causes, but like I said, they made it for like 3 days after my release. So then I went to it, and then it was 3 days after that they made another one, and I didn't have a phone or anything to be able to attend that one.
Okay, so how
But
about
I will not miss any other hearings. I promise you that. Like, this has been like the worst time I've ever done in jail. Like, I have nobody. I can't even use the phone. I can't talk to anybody. I have no way to contact anybody. I'm indigent. Your Honor, please, I'm begging you to just let me. I have multiple evidence in my case that I need to be able to go obtain on the streets, because I'm my own attorney, like I said, and I have nobody to do that for me.
Okay. Is there a reason why you don't want an attorney? I mean, this is work that an attorney could be doing for you.
Yeah, I know, but I've had bad experience with attorneys in the past, and I just, like, I've been researching all this myself, and I've just been taking care of it myself. I just need to be able to get out and get that information for you, Your Honor.
Okay, so do you have a phone number where the court can reach you and send text reminders of your court dates?
Yes.
Okay. And let me know when you're ready. Okay, what's that number?
Your Honor, I think Ms. Pritikin has made the state's position known, but I just want to reemphasize that there's been nothing to change any sort of consideration as when bail is imposed in these two cases. Superior Court, she's not being held on Superior Court. However, I've reviewed both.
This may be the most emotional moment in the hearing. The defendant stops talking like a legal advocate and starts speaking like someone who feels trapped. She says jail has been unbearable, that she has nobody, no support, and no way to defend herself properly while locked up. And emotionally, that's powerful. But in court, emotion alone rarely changes outcomes. Judges hear desperate pleas every day. They hear promises. They hear I won't miss again. They hear I've learned my lesson. What they're really listening for is something deeper, evidence that the risk has changed. That's why this moment is so critical. She's trying to convince the judge that the person who missed court before is not the person standing there now. And that's incredibly hard to prove in just a few minutes. Still, the judge hasn't shut her down. That's important. He's listening, which means the door is still open. But make no mistake, one wrong detail, one inconsistency, one sign that these promises won't hold up, and the opportunity disappears instantly. So the question becomes, does the judge believe this is genuine accountability, or just panic at the reality of staying in jail? That answer is coming right now.
And getting me arrested. Like, he lives on Lemon Road, and I live on Kinney Road, but he comes there and gets me arrested. So how is that? I don't understand.
Well, if there's a protection order between the two of you.
Yeah, but how does he come to my house and get me arrested when he doesn't live there?
But that is part of how these orders work. Is you're not, and yeah. Again, I wasn't the judge.
That's also another change in circumstance. Like, he comes to my house and gets me arrested. You know, like.
All right.
I promise, Your Honor, I will not speak with him anymore. I will not accept any calls or try to contact him at all. I'm begging you, please just review these conditions or PR me, please. Like, this is, like I said, this is the worst time I've been in jail. I'm willing to do whatever I got to do to satisfy the court and work with the district attorney to resolve my cases. Please just give me this one more opportunity. And if I fail on this, like, I don't care how long you give me. I really don't.
And ma'am, if you can't go back to that address, where are you living? Okay. And is that a friend's house, or where does that
Yes,
address?
that's my family's house.
Who lives there?
Brian Michael,
I mean, like your relationship to them.
my cousin. And I can receive mail there.
All right. So since you're going to be staying in the area, okay, what I'm going to do is, so I'm going to release you, but I'm going to impose some heightened release conditions that require some pretrial services supervision.
Okay.
Because it seems to me that the biggest issue that I'm looking at is the failure to appear history, particularly in this case. And so
This is the turning point, and it's not the outcome many expected. Despite the prosecution's concerns and the missed court appearances, the judge decides to release her. But this is not mercy without consequences. What the judge is doing here is creating a controlled release structure. Instead of keeping bail in place, he imposes pre-trial supervision, meaning she'll now be under direct monitoring. She must check in, remain reachable, and comply immediately, or the court can revoke release and reimpose bail. In other words, she's getting another chance, but it comes with a leash. This is a powerful example of how judges balance accountability with fairness. The court recognizes that jail may not be necessary right now, but the judge also makes it crystal clear that freedom is conditional, and psychologically, this puts enormous pressure on the defendant, because now, any failure won't be blamed on misunderstanding. It will be seen as a direct violation of trust. The judge has given her what she asked for, but with a warning attached, and in many ways that warning is more serious than the bail amount itself. Now the responsibility is entirely hers.
That's the protection order violation. I'm going to, I guess, not set bail in the amount of $5,000, but so I'll release you on your own recognizance there, but I'm going to impose as a condition of pretrial release, pretrial services supervision. So you'll get a copy of a judgment sentence order, ma'am, there at the jail.
Okay.
It has the phone number for pretrial services.
Okay.
All right. It says you have to contact them within 48 hours, and their phone number is right there on there. Okay. Sounds
so
like
on Monday?
Yep.
Okay.
And so you'll need to spend the weekend making sure you get a good phone that you're able to utilize, because if they don't get that call from you, they're going to send in a violation report, and then you're going to have a lot of FTA. You're going to have a lot of failure to appears, and then failure to check in with pretrial services, and so you're looking at the possibility of more bail there. All right. So all other conditions remain the same, except for this pretrial services supervision requirement.
Okay.
You've got court dates already set. This was just set for a review hearing.
Yes.
Do you know your court dates?
Yes.
All right. So your next court date on all your cases is December 17th at 10 a.m. You're going to get this copy of this judgment sentence order that has your next court date on that as well. So you've got to have a hard copy of that.
Okay. Thank you.
Okay. All right. So no problem. So pretrial services supervision on that. And then on the matter ending in 6853, that's the DS3, a no ignition interlock device, in which you're held on $1,000. I'm just going to PR you on that. I'm not going to add any other conditions. That's going to just be on the one case.
Okay. Thank you so much, Your Honor.
All right. Yep. Good luck, ma'am.
Your Honor,
Thank
the
you.
last thing I think that before Ms. Martini leaves.
And before you leave, yep.
Yeah.
Stick around here, ma'am.
As she is going to be representing herself on these cases, she'll need to receive discovery.
In the end, this hearing wasn't just about bail, it was about trust. The defendant came into court facing the consequences of missed appearances, protection order allegations, and the weight of representing herself in a high-stakes moment. The prosecution argued that nothing had changed, that the risks were still there, and that the court had no reason to believe release was appropriate. But the judge saw a narrow path forward. Instead of choosing detention, he chose supervised release, giving the defendant one final opportunity to prove she can follow the rules. That decision sends a powerful message. Courts are willing to offer second chances, but only when there's a structure for accountability. And now, the future of her case depends entirely on what she does next. Will she follow through on every promise she made in that courtroom? Or will this second chance become another missed opportunity? That's what makes hearings like this so compelling, because the ruling is only the beginning. If you found this courtroom breakdown as intense as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe to Trail Told for more jaw-dropping courtroom breakdowns and real legal drama every week.